Good morning and welcome everyone to PRBA National Conference. Bienvenidos, buenos días a todos a PRBA National Conference. My name is Rebecca Arenas. I am the CEO of Legal Services Clinic of the Puerto Rican Community. Soy la CEO de Legal Services Clinic of the Puerto Rican Community. The Legal Services Clinic of the Puerto Rican Community was born out of the necessity of past Hurricane Maria on the island of Puerto Rico. Pursuant to the rules of the Florida Supreme Court, Rules 11, 12, and 13, we are a certified legal services provider to the indigent population of Florida. We are a non-for-profit 501c3 organization which is now providing free services to persons who qualify under the federal poverty guidelines. Legal Services Clinic nació luego del huracán María y estamos certificados bajo el estado de la Florida para proveer servicios completamente gratuitos a las personas que cualifiquen bajo los niveles de pobreza establecidos por el gobierno federal. It's an honor for us that you are participating in our first national conference, which is an event to fundraise for the clinic to keep our doors open for our community in need. Le estamos agradecidos y honrados con su presencia a participar de nuestra primera conferencia nacional, que es para recaudar fondos para mantener nuestras puertas abiertas para seguir proveyendo servicios legales a nuestra comunidad en necesidad. First of all respect to everyone's religious beliefs. I would like to pray. So if you can bow your head, thank you. Dear Father who is in heaven, we want to thank you for this day. Thank you for everyone who is here. Lord, please take control of today's agenda, protect those who are on their way so they can arrive safely, and at the end of the day, bless everyone so that they can reach their home safely too. May our day be blessed. In Jesus' name, amen. Así que oramos y le dimos gracias a nuestro Señor por este día y pedimos por aquellos que vienen de camino que los bendiga, los traiga con bien y luego nos devuelvan sanos y salvos a nuestras casitas. Now I would like to thank our sponsors. Thank you for supporting our event and the clinic. May God bless you in abundance. Thank to Let Us Claim, our major sponsor. Thank you Puerto Rico Statehood Council, Laguna Legal, Hispanic Federation, Professional Insurance Experts, Tonelli Law, Forensic Group, La Prensa Orlando, Richport Capital, Dex Imaging, Rocha Financial, Suarez Title, Suarez Mortgage, Suarez Law Group, Suarez Realty, Ferraiuoli, Latino Justice, PRBA of Florida, PRBA of Illinois, National Puerto Rican Agenda. Okay, PRBA of Illinois. Yes. National Puerto Rican Agenda, Colegio de Abogados y Abogadas de Puerto Rico, Centro de Periodismo Investigativo, and Puerto Rican Chamber of Commerce of Central Florida. So let's start with our first CLE of the day presented by Centro de Periodismo Investigativos. Enjoy and have fun. Today we have a nice agenda. You can look in the book that you have on your back. Thank you.
Good morning, buenos días a todo el mundo. Thank you for having us. My name is Carlos Francisco Ramos Hernandez, and I'm here with Carla Minet, Executive Director and Editor-in-Chief of Centro de Periodismo Investigativo. Before we begin, and I know the time is always of the essence, I want to thank the organizers, Mr. Anthony Suarez, Rebecca Arenas, for helping us and for inviting us. We're delighted to be here and talk about a very important subject, Puerto Rico and the Fiscal Control Board, a legal guide to transparency, accountability, and access to information. I am currently the staff attorney of the transparency program at CPI. I was formerly an Equal Justice Works Fellow, dealing mostly with working as a public interest lawyer. And I'm also an adjunct professor at law at the University of Puerto Rico and the Pontifical University of Ponce. and Carla Minet, as I mentioned, Executive Director and Editor-in-Chief of the Centro de Periodismo Investigativo. Some feedback. Is it all good? Right there? All right. All right, so what's the agenda for today? First of all, what is el Centro de Periodismo Investigativo, or CPI for its acronym in Spanish? Then I'm going to talk about what is access to information in different levels, federal, international, and state level. Then Puerto Rico's constitutional right of access to information, its history, and its most recent law approved in 2019. Then we're going to delve into litigation, CPI's cases against the Fiscal Control Board. They made it all the way to the United States Supreme Court, and a current litigation that we have against the U.S. Treasury Department, currently being seen at the Southern District of New York. Then we're going to have a conversation with Carla from the journalist perspective of how all these cases started, because at the end of the day, what we do is support the work of the journalism investigative reporting that CPI does. Then we'll have some final practical tips for submitting public information requests in Puerto Rico, and then we're open to questions you may have, and I feel you're going to have several. It's a very interesting subject. I know the CLE approved materials were sent beforehand, but we added a few things. We're going to talk about it, a guide that we're launching today with you all, that we did it in Spanish, and the English version is today up in our website. And then obviously the case against the Treasury, the latest filings were a few weeks ago, so we added it. So if any of you want, we have a QR code that had the link. I can post it later too, but all the most recent materials from the CLE that have been updated are published there. So I'll leave that for a bit and then we'll start. All right, Centro de Periodismo Investigativo started in 2007 as a non-profit news media organization focused on government transparency and dedicated to promoting and defending access to information via three ways. Investigative reporting, that's mostly what people know us for, the work that the journalists that work at the Centro do. But we also do a lot of litigation, and I'll talk about the next slide, because that was one of the key components when the organization was founded. And we also do journalism training. CPI has an institute for professional development for journalists as the continuing education, also for journalist students at the university. We give out grants if they were doing a reporting and they want support, and they also have access to legal representation if need be for journalism students. We do in-depth investigative and independent journalism without political or commercial ties. Whether we're investigating federal recovery money from Hurricane Maria, environmental and climate change issues, cronyism, corruption, coverage of earthquakes, the pandemic, we serve as watchdogs holding those in power accountable. In terms of litigation, the transparency program, when the CPI was founded, at the same time we entered in a collaborative agreement with the Inter-American University of Puerto Rico Faculty of Law, and we founded a legal clinic section, the Access to Information Clinic. Currently, they have different clients, not only CPI, other journalists, civic organizations, environmentalists, activists, mostly First Amendment litigation or access to information litigations. In terms of their work with CPI, we do impact litigation. We have filed 37 lawsuits between Puerto Rico courts and federal courts, and I may say we have a very good winning record, 90-95% streak of winning cases. Out of the transparency program, we also do civic education, know your rights workshops, something what I'm doing today. That's most of my jobs on a monthly basis. Journalists, attorneys, students, activists, and the public in general. And then we also do some policy reporting and some advocacy for pro-transparency initiatives, and I'll mention them as the presentation goes on, because it tackles a lot of the issues of the laws in Puerto Rico or our constitutional right to access information. But people know us mostly for two things, and I'm gonna let Carla mention them, with this reporting on the real death toll following Hurricane Maria. We were the organization that went into court and filed a lawsuit, and we found that actual number. There was a lot of reporting done afterwards, and obviously the first news organization that published the Telegram chat that eventually led into Governor Rosselló forcing his resignation in the governorship. I would like to Carla to comment that from a journalist perspective before we delve totally into legal stuff.
Good morning, everyone. Thank you, Anthony, and everyone for inviting us here. So yes, we just wanted to highlight that when we talk about access to information lawsuits, wanted to give you a few examples on why it is important for us to get public documents. After Hurricane Maria, one of the most important litigation we did was to get the cause of death database in Puerto Rico. This is a huge database that has over 100 categories or fields of information. And after Hurricane Maria, we wanted to know who, how were those deaths being cataloged in the cause of death database. We knew most of the death of Hurricane Maria were not directly related to winds, floods, etc., but to other issues such as the lack of electricity mostly, but also like infections like leptospirosis, which was one of the causes of death that it was a breakdown after Hurricane Maria, and this is like a disease that you get from mud, water, and debris, etc. So we wanted to know who was dying, where, and why, because the recovery efforts were taking so long that we knew that there were things that could be done to stop people from dying, but we didn't know where were in which towns were people dying, how old were they, the demographics, etc. So that's why this cause of death database was so important to us. And the government didn't want to give us the database, even though we had won a lawsuit for this same document before before Hurricane Maria. So we went to court again. We fought this. CNN joined us in the lawsuit because we were doing an investigation together with them, and we also got the death certificates as part of the lawsuit from most of these people, but because the death certificates is where you can see what the doctor said about that death, the exact words, etc. So we also were able to get those records. We investigated, and we finally, a year after the hurricane, we published an investigation that said this is the people who died who were not acknowledged by the government as death related to Hurricane Maria, and these were their causes of death and their circumstances because we interviewed their family members. So this is just one of the examples of when we go to court for public records, what we get. They are very important documents that allow us to do an investigative work and accountability work that no one else is doing.
Thank you, Carla. All right, let's get into the legal stuff. Right of access to public information. First of all, it's a human right. It's all individuals have a fundamental right to request and receive. It goes both ways. It's not only asking the government. They have the right includes receiving the documents in their possession or in their custody. It's been recognized in Article 19 of the Universal Declaration of Human Rights, multiple international and regional treaties and agreements, and more than 130 countries have freedom of information rights and laws known as the oxygen of democracy. Without knowing how the government operates, you cannot fully participate in democracy. And when I talk about citizen participation, I mean it more than voting every 4 years. It's speaking out, it's gathering with your community, it's going to protest. It's all the ways that, in terms of U.S. language, First Amendment rights are exercised. And it's also a pillar of government transparency. Just to give you comparison legally, international level, as I just said, is a fundamental human right. First Amendment, there is no federal constitutional right of access to public records. Yes, there's a common law right to information, and I'm going to go into depth in each of them. At the federal level, what we have, and you all may know, the Freedom of Information Act. It's a statutory right approved in 1966, but any day Congress can take it away, and there's no way of knowing public records from the executive branch, because FOIA, and I'll talk about it later, only applies to the executive branch. It does not apply to Congress or the federal judiciary. At the state level, there are 7 states that have a constitutional right to access public records. All 50 states and territories do have open records and sunshine laws. In Puerto Rico, it is a constitutional right since 1982, yet its first and widely opposed, and I can comment it when we talk about the law, was enacted in 2019. So there's a difference between that, and there's a history because of why that is. In terms of the First Amendment, Hutchins, it's a case from 1978. It involved news organization who wanted to investigate the conditions in jails, incarcerated people in California, and they were denied access to videotape what was happening there, and it made it all the way to the Supreme Court. It was a divided decision 4-3, but it ended up saying neither the First Amendment nor the 14th Amendment mandates the right of access to government information or sources within the government's control. The public interest of knowing is a guarantee of the Free Press Clause, but it's only indirect. The Constitution itself is neither a Freedom of Information Act nor an Official Secrets Act. That was a big blow. There was a lot of support from journalist organizations in '78, and they made another push in 2013. The McBurney v. Young case, that was an unanimous decision, and the court reiterated that we have made it clear that there's no constitutional right to obtain all information provided by FOIA laws. The McBurney case is very interesting because it's a case that came out of Virginia, and it was an out-of-state resident who wanted to know commercial tax records from Virginia, but he wasn't a resident of Virginia, and Virginia's open records law, its state law, prohibited. It had what's called a residency requirement that if you're out of state, you can file a public records request. And the requester filed a lawsuit arguing that violated the immunities clause because it affected interstate commerce, and it also made a First Amendment argument. Unanimous decision, across party lines, appointed judges. Everybody says no, FOIA is not a First Amendment law, not constitutional right. But that doesn't mean that there isn't First Amendment protections in terms of access, and you all may know the famous Richmond newspaper case, which involves physical access to courts, proceeding, specifically criminal trials. That's part of the guarantees of the First Amendment. But the U.S. Supreme Court has yet to directly address whether the Richmond paper holding expands to civil proceedings. So currently, there is no constitutional right to access physical civil proceedings in courts, yet most federal courts of appeals who have dealt with this case have recognized sort of a qualified right to access civil trials and other related proceedings. And in terms of criminal trials, obviously, it depends on the stage. There's a test, the press enterprise test, depending, because each state has different criminal proceedings. In Puerto Rico, there was a big case, El Vocero case from the 80s, because they denied access to the press, and it made it all the way to Supreme Court. And following the Richmond papers holding, it decided that those court proceedings, which are preliminary hearings, vista preliminar, in Puerto Rico had to be open. But in terms of what First Amendment protects in terms of access, is physical access to court proceedings, to criminal proceedings. But there's a common law right of information. It's been on the books since the 19th century. The earliest cases are from 1850, more or less. And it's a general right of inspection, and copied documents. And it's mostly used for judicial records. If you're asking judicial records, a copy, if you're not a party in a case, for example, and you want to have access to a transcript in a federal court, you're probably going to rely, probably the court has in local rules, it might have some rules regarding accessing public records, but you're usually going to use common law right as a basis for accessing those judicial records. The difference is and we'll see how different public records laws apply, but you need to show a special interest. In modern day, access to information rights and laws and jurisprudence, there's no need to show a special interest. You know, the mere fact that you're a citizen, participant in democracy, you can have access to courts. But if you rely on the common law right, you have to have a special need, a direct, tangible interest, and there has to be a balancing test between the government's interest. I mentioned the Nixon-Warner communication case from 1978 because they were trying to access the tape recordings that President Nixon had in his office that eventually led to force his resignation, and the U.S. Supreme Court directly dealt with the common law right of information in that case. I highly recommend this law review article, The Common Law Right of Information. It's in the materials. It really expands on the history of the common law right of access, which is different from the First Amendment, but it's usually the one used, as I said, for judicial records. All right. I'm just going to give a general overview on FOIA, the Freedom of Information Act. I can give an entire CLE on FOIA. It is very bureaucratic, very complex. Journalists hate them. Everybody hates them, but it's the law that we have for accessing public records at the federal level. As I said, it only applies to the federal executive branch. That includes the president's office, CIA, FBI, you name it. You know, there are 9 exemptions, as I mentioned. National security is the biggest one. It swoops the first exemption. Everything gets swooped under the rug with that. It's very hard to access records, and litigation is very complicated. Congress, you can't access Congress, even if there are communications between congressmen and the executive branch. It might be completely redacted from the side of Congress. And it doesn't apply to the federal judiciary. You can send a FOIA request to a federal judge, the justice of the Supreme Court, any of that. In terms of the scope of FOIA, it's available to any person, so that difference in terms of a citizen requirement or residency requirement, there's some exceptions, does not apply. It's a presumption of access. And actually nowadays, most of the Professor Margaret Quokka, which is the leading expert in FOIA right now, she's a professor of law at the Ohio University, she has found what they're called FOIA logs and analyzed the type of requesters. Currently, the 2 most requesters in federal agencies are immigrants, you know, who want to know about their status or their proceedings because their immigration cases are taking so long. The way of like go around the system and know how their case is going is filing a FOIA. And then the other biggest part of requesters at the federal level are commercial requests. There's a parallel service. People are buying public information and reselling it. Talk about the FDA. If you're a very good file of FOIA of FDA, you can get access to public records before things are announced or not, and you can sell it to a competitor. So right now, most of the things that are FOIA is being used for is not as a watchdog. It's not to serve the public interest. There's a complete industry. There are a lot of calls to reform FOIA, different ways. DOJ federal DOJ is the agency in charge with National Archives of overseeing the implementation of FOIA. There's a lot of work going on, but it is very complex, and it's not serving the purpose which was originally enacted for. In terms of what can you access with FOIA, records, they must be maintained by the agency, so it's a very specific definition. There are a lot of things that don't count. You know, you can't file a request for a computer, a cabinet, or things like that in terms of FOIA. There are time limits, usually 20 business days, but there can be extensions over and over and over. And the first deadline is acknowledgement of receipt, and you can be in the acknowledgement period for months. And then there's an expedited processing, but that requires justifying why you need it. The press usually uses that expedited processing, but it doesn't mean that you're going to get it fast. Fees and waivers. This is one of hardest things sometimes in FOIA. You get charged for search, what the government employee times it takes searching, reviewing, even if they're duplicates of the information you're requesting. There's a waiver to those fees if you're a member of the press, if you're an educational institution, if you're doing it for educational purposes. But it's very complex, and from the get-go, the public records request has to have all that information. You know, if you're subject to fee, how much can you pay? If you're requesting waivers, why do you qualify for waivers, and things like that. There are 9 FOIA exemptions. Later, when we talk about the CPI's case against the Treasury, we're going to focus on 2 of them, which is the pre-decision and deliberative processes. which has to do with drafts mostly and like internal communications, intra-communication from the agencies, and the unwarranted invasion of privacy, whether that information that the government has is attacking the privacy of other people. Obviously, you all know famous redactions, the black redactions, but there's something called segregability, which is the agency has the obligation to segregate any information that is not covered by an exemption. That's why sometimes you see part of the redactions that you can see, little snippets, but that's it entires a different kind of legal argument. We are dealing with that in the Treasury case, and it's not as easy to try to argue segregability. And then finally, most of the agencies have internal administrative appeals. I highly recommend that you always appeal before going to court, because it's going to get reviewed by somebody, an independent body within the agency, and they could unredact and release information that they didn't give before. Once you get to court, there have been like 5 trials of FOIA case in the history of the U.S. It's usually summary judgment because there is no fact dispute. You know, everybody knows what happened. It's a legal dispute whether the exemptions apply or not. Usually, the agency has to file what is called a Vaughan Index, like a privilege log, and they have to justify under sworn statement why each section of the redactions apply, and you got to review that presumption, and then it usually goes through summary judgment. But it's a very technical and niche litigation, and I've learned that through experience of the case that we're having now. It's very different from any other public records cases. But people usually settle, you know, when you're negotiating with the agency, you know, you release these, I don't want the rest of the production, for example, things like that. All right, at the state constitutional level, I just want to mention the states that have a right in their constitution: California, Florida, Illinois, Louisiana, Montana, New Hampshire, North Dakota. And since we're in Florida, this is the provision in their constitution. They're also known as sunshine laws, and it started here in Florida too. Sunshine Week is celebrated the 3rd week of March. I know it very well because the same week of my wedding anniversary. And my wife's like, so you are a FOIA attorney and you have to celebrate Sunshine Week on the same week? That is insane. So we're fighting for anniversary dates and whether I have an activity with El Centro. If you're interested in, you know, state public records law, I highly recommend the Reporters Committee for Freedom of the Press. Is a nonprofit organization who's been an ally from the center for the longest time. They provide free legal advice to journalists all across the U.S. They have a hotline available 24/7. They've litigated cases to the U.S. Supreme Court. They file constantly amicus briefs, and they also do all their types of media law and First Amendment litigation. And they have an open government guide that has all 50 states, and it provides an in detail prepared by attorneys everything you need to know about public records laws in those states. I also recommend this law review article, which, you know, deals with the McBurney-Young decision and the problems of why isn't there a constitutional right to access information at the federal level. It's also in the materials. All right, we'll get a little water, and then we'll start with Puerto Rico. All right, just a general overview. Puerto Rico, even though the constitutional right is from 1982, as it says there, we're going to talk about that landmark case right in a moment. There's been a statutory right since 1905, similar to the common law aspect. It came all of that. It's in the Code of Civil Procedure. In the case of Puerto Rico, that was inspired from the California Code. So it is directly linked to the common law right of information. In 2019, the Puerto Rico Transparency and Expedited Procedure for Public Records Law, which I'm going to talk about later, and we're going to delve into all the aspects for filing that request. And then from the work at CPI, there are 2 things that are very important. We did a policy report of the government's non-compliance with Act 141/2019, and we filed requests in every 78 municipalities, every 121 agency, just to see if they were doing what the law requires them to do, set up the bureaucracy. And then in terms of a general public guide, the basic guide for submitting public information requests, it is directed for non-attorneys, but it has a lot of legal information, and that's the one that we translated in English for this conference, and I'm going to show later a QR code that you can also access to. Right, just like a general overview of Puerto Rico's constitution, approved in 1952, ratified via popular vote, but ultimately authorized and modified by the U.S. Congress. And I know you'll talk about a lot of the Puerto Rican constitutions and the other CLEs. There was a Constitutional Assembly. They were all men except 1 woman. And there were participation for every political party except the pro-independence party, who didn't recognize that process as a legitimate constitutional process. terms of separation of powers, it is interesting to know that under the Puerto Rico Constitution, the judicial branch can recognize new fundamental rights. There's no need to find a legal interpretation for it. Article 19 of the Bill of Rights explicitly says there are other rights that can be recognized by this court that belong to the people. And Puerto Rico's Bill of Rights, inspired by the Universal Declaration of Human Rights. In terms of federalism, of course, supremacy clause from the U.S. Constitution, similar to a states, and the plenary powers of the territories clause, which is definitely, we'll talk about it when the board case, and I'll talk about it in the other CLE courses. And I just want to make this general observation from constitutional litigation in Puerto Rico. The Puerto Rico Constitution, since the federal Constitution sets the floor, and states and territories can expand beyond that, it's always been known as a more global and protective vision, and that's the case, an access to information case. But it's very important to understand that most rights from the Constitution in the Puerto Rico are self-executing, and some are actionable against private individuals, and are mostly enforced through extraordinary remedies, the writ of mandamus we're going to talk about, or declaratory judgments. This is very different from enforcing constitutional rights at the federal level, which usually requires a distinct cause of action. For example, in 1983 civil rights claims, you don't need to have a general statute in Puerto Rico to tie it together to your constitutional claim. You can just invoke the provision and that violation. When it comes to the remedy, though, if you want to have damages, for example, then you need to have a cause of action for the General Torts Act in Puerto Rico. But in terms of access to information, which the remedy is obtaining records, the first cause of action is violation of Puerto Rico's access to information right. That's it. And that is very distinct from federal litigation, and I've had this with lawyers trained in the U.S. I always like to mention it. All right. How do we get to Puerto Rico's constitutional right to access to information? And we got to talk about the murders in Cerro Maravilla, July 25, 1978. Two pro-independence university students, Carlos Soto Arribí and Arnaldo Darío Rosado, were entrapped by an undercover police officer, ambushed and murdered at the Cerro Maravilla Mountains. This was, you may remember the hearings from the Senate in the early 80s. But following, one of the things that came out of that tragic incident and dark period in the history of Puerto Rico is that the students' parents and widow and an activist organization submitted a public documents request because they wanted a copy of the police investigation and the report which exonerated the officers for any wrongdoing. Initially, the Court of First Instance denied that request. They made it all the way into the Puerto Rico Supreme Court. And in this landmark opinion, they recognized that out of the Puerto Rico's right to freedom of speech and freedom of the press, it recognized a new right to access public information, and it ordered the government to release the report. The government had argued that there was a law from the local DOJ department that indicated that report had to be kept confidential for 30 years. We would have received it a few years ago. And that was the law that the Puerto Rico Supreme Court declared unconstitutional. Yes, 40 years. The case was 40 years ago. And the court found to be unconstitutional. So that's the basis. So I always like to mention that it's a citizen's right. It's not a press right. The press is the one who uses it the most for part of the reporting, but any citizen in Puerto Rico can file a public information request for whatever need. I always mention the movie's not that good, but a show of force, it was an intent to talk about what happened in the Cerro Maravilla case. But the book, The Two Lynchings of Maravilla, by Manuel Manny Suarez, a very well-known and famous investigative reporter from Puerto Rico. It is very hard to get that book nowadays, but it makes an amazing recount what happened throughout the weeks and following the hearings and eventually even the Soto case. And one of the famous pictures from the hearings that were widely televised in Puerto Rico in the early 80s. All right. So in terms of constitutional aspects of right of access to information, as I mentioned, every citizen has this right to examine. The definition that we've used for the longest time to access public records came from the Public Documents Administration Act. Any document which is originated, kept, or received in a dependency of the Commonwealth of Puerto Rico. The Puerto Rico Supreme Court, in a case in the early 2000s, said that any citizen has standing the act of denying itself causes an applicant a clear, palpable, and genuine harm. So there is no need to make any standing analysis different from that one. You're denied, you have standing to go to court. In terms of the procedural mechanism, the classic way of enforcing this right is through the writ of mandamus. It is extraordinary remedy directed towards usually the head of the agency, demanding compliance with a ministerial duty. You know, you have to request it, and they have a duty to provide it. This sort of cases are usually seen in the Court of First Instance in San Juan. There are specialized courts that deal with injunctions and mandamus, and they move very fast. And journalists usually prefer that we file cases through mandamus and not the other lawsuits that I'm going to talk about, because you get hearing very fast. It's the same ones that handles injunctions and TROs. And it's been said that this is the mechanism historical to do it. In terms of the standards, one of the judges that usually deals with these cases in San Juan, Judge Anthony Cuevas. First thing the court has to see whether the record in itself is public, and it goes to the definition that I just showed you, and sees it is originated, has been kept. Once you pass that threshold, the property burden is on the state. Shows there's any confidentiality exception that limits the production of that right, of that document, but it must be accurately and unequivocally proved. It is a very high bar that a confidentiality exception applies. All right. And then the exceptions that have been recognized by the Puerto Rico Supreme Court, there are 5. Whether a statute declares that itself X or Y information is to be kept confidential. If the document is subject to evidentiary privilege, spousal privilege, attorney-client, that's a valid exception. If the information reveals harms the fundamental rights of third party, usually right of privacy, like we don't have a right, for example, to access social security numbers. It might be in a form that you're accessing. It might be the rest of the form might be a public record, but you don't have access to that because it harms the privacy of third parties. Another exception, it may reveal the identity of a law enforcement informer, ongoing investigations, and official information is one that is usually invoked a lot by the government, information that is obtained by the mere fact that you work for the government. These privileges and exceptions are supposed to be construed restrictively. Okay. In terms of judicial review, once the government invokes an exception, the judge, and this is one of the other judges from that specialized courtroom, Judge Alfonso Martinez Piovanetti, they have to use equivalent to a content-based discrimination, First Amendment judicial review, strict scrutiny, and they must show a compelling government interest. And if you do constitutional litigation, or you remember from law school, if you have to invoke a strict scrutiny, you're almost doomed. So we usually get access to the records in that regard. And I just want to briefly mention one of the 2 most important cases that made it all the way to the Puerto Rico Supreme Court for access to information. This case from 2017 has a lot of relevance to the Fiscal Board case we're going to talk about later. Then Senator Batia sought a published copy of the proposed and draft general budget for Puerto Rico that was submitted to the Fiscal Control Board. This is the first year of the board in Puerto Rico, and the House has to approve the board, and then they submit it to the board for its approval. This time around, they didn't want to show the proposed and the draft budget, and it was a time-sensitive issue because they wanted to see who was proposing which cuts. Was it the board or was it the government, who was proposing the cuts? It made it all the way very fast to the Puerto Rico Supreme Court, but they applied a deliberate process of privilege. They required an inspection review. Eventually it was released, but it was time sensitive. By the time it was released, the budget was already approved, and there was no way of trying to see who was proposing the budget cuts. The effect of this was that the government saw this as a positive. They proposed, moving forward, every of the remaining budgets that have been submitted by the Puerto Rico government to the board, they made it public. Because they know the one who's going to make the cuts is the Fiscal Board. So now they propose a huge budget that they know is not going to pass, and then the board is the one who makes the cuts. But that would have happened if this litigation hadn't had a core, because the first one who pushed to see, we want to see the draft. We want to see the draft before you submitted it to the board. And then the last decision from the Puerto Rico Supreme Court in this aspect is a Kilómetro Ceros against the Puerto Rico police. Kilómetro Cero is a civil rights nonprofit focusing on accountability and mostly denouncing police brutality. And I don't know if you know, but Puerto Rico police is currently under reform for a lot of things, including the excessive use of force. And they wanted to have access to those reports. And the government fought it all the way to the Puerto Rico Supreme Court. And it could only redact personal identification information and order its release. And this is a case that we're very proud of too, because the lawyers who are usually the work at the clinic that give services to CPI, they're lawyers that took this case and made it and won it. And it established a very good precedent, the Kilómetro Cero decision. All right. So now I covered general constitutional aspects. Now we're going to talk about the Transparency Act and a little bit of the history of why we have a right. We have in a code from 1905 and then a right in 1982, but we didn't have a general public record statute like the FOIA until 2019. Since 1973, there have been more than 15 bills and 2 executive orders to regulate public records requests, but the press has historically been opposed to this sort of rights statutes because they see as a way of losing their exclusivity. They have their connections, they have their sources, and they want to be the first ones to get the records even though they're public information. So in 2016, CPI and other civic organizations endorsed a comprehensive bill, at that time bipartisan support, to strengthen the right. It took a lot of educations and workshops, and we, CPI, got support for more than 30 independent, from journalists, from independent, whether in the independent character, from civic organizations. The bill didn't pass, but we changed the mentality that it was important for everyone to have a statute that regulated access to information. But then the government changed. Governor Ricardo Rosselló came into office and he introduced pro-transparency bills, yet he decided to approve them in the midst of the heated summer of 2019 where people were out in the street protesting. They were approved without public hearings. They were strongly opposed by the press, and they were actually signed into the law the day before he was supposed to resign. At CPI, we see a sort of like a vengeful decision against the press. And the Transparency Act is imperfect, deficient. It should have never been enacted. And that's been most of my role for the past few years, is seeing what parts of this law are good and help the people of Puerto Rico. But in reality, it shouldn't have been approved because after so many years of fighting for this kind of law to regulate a constitutional right, to give deadlines to the agencies to answer, it is a shame that it happened in the darks at a very different and hard summer for the people of Puerto Rico. Nonetheless, we're going to talk about the Transparency Act, which is the current law, and it applies to the entire government of Puerto Rico, including the executive, the legislative, and the judiciary branch. So you can file a public information request to all of them, different from FOIA, public corporations, municipalities, and this is very important, third-party custodians of public records. Puerto Rico is having a lot of privatization lately. Think about Luma and the power electricity. Think about the airport, which is privately run. Think about a lot of the roads that are now privately run. You can file public records requests to them because the law now allows third-party custodians so you can access information to them. The definition is a little bit broader because it's not only physical documents, it can be general information, which includes now electronic and metadata and all things like that, generated, kept, received. Now they're all presumed to be public. In terms of proactive disclosure, the government should proactively, on their websites, constantly be publishing information. I can tell you that they're not doing it, but that is currently the law. Just to give a general idea and narrow and give examples, similar to the Transparency Act, there was a Puerto Rico Open Government Data Act that was enacted at the same time. And under this law, every agency in Puerto Rico should have on their website right now their following information: budgets approved and their quarterly expenses, strategic plans and their results, their personal compensation, their business hours, their telephone directories, their bids and proposals for works and services, any contracts executed with public funds, in terms of environmental, all the impacts and the zoning and all the permits that they get. I can assure you that that is not being abided right now. It is very hard to get any of this information, which may seem basic for any other sort of government, knowing how much public employees being paid, or if they have a strategic plan to enact public policy. They're supposed to be in each agency's website right now. They're not, but I use this as an example of all of the scope of information, categories of information that you can file a public records request in Puerto Rico. Now I can talk about CPI's experience. Other public records, we talk about the mortality, the databases, but we filed requests, and many of them lawsuits, to get fines imposed on political candidates, reports regarding the bondholders who bought the public debt, the natural disasters emergency plans. We had to go to court to get what was the agency plans for natural disasters, lobbyist registry, budgets and enrollment numbers for every public school. You imagine that would be easily accessible in the Department of Education. No, we had to go to court to get those records, and the journalists could do their job. Annual reports on the beneficiaries of Act 22, the exemption of capital gains, which has been a big issue on the island recently. We had to go to court, and it wasn't until fairly recent that we got access to the full reports after years of litigation. They made it all the way to the Puerto Rico Supreme Court. And statistics, and it was a very big investigation on complaints on domestic violence from police agents against their partners, which is very problematic. You have police agents, they're incurring in these wrongdoings, and they're still active in the force, and want to have statistics on that, and statistics are very alarming, to say the least. All right, so how do you submit a public records request in Puerto Rico? Any person can submit a public records request, written, by email or electronically, regular mail, or in person. There is no residency requirement, so no problem with the FOIA and Virginia McBurney case. You're out of state, you can file a request. There's just 3 things that you need to have: an email address when you want to receive the notifications, the format and delivery method. I want a PDF, I want an Excel, and you can send it in a Google Drive, and or Dropbox, whatever is easiest for you. And you got to describe the records as best as you can that you're providing. If you have all of those 3 things, you should be fine. A requester is not obligated to inform the government what you're going to do with that information, or the government cannot inquire about what are you going to do with it. Why are you requesting it and what you're going to do with it, and which translates that there's no need to show a private or legal interest on the records that you're requesting. Who do you send the request to? Act 141, the Transparency Act, created this new figure, which makes all the sense in the world. Public Records Officer didn't exist before. There are FOIA officers in every federal agency. Agencies in Puerto Rico didn't have a main contact in the agency that processed this request. They're the main contact. They just receive them. They're supposed to have trainings on the applicable regulations of access to information in Puerto Rico. They should be receiving a workshop, a CLE, just the one that I'm giving you today, and I'll give you a little bit more information on that. They got to prepare records log, normal bureaucracy, and they should have the names and the contact information of all these officers on their website when a central government agency. You can also send a request to press officers or the head of agency. But, and I'll talk about the report that we did. We had a suspicion that most of these public records officers weren't named. So we filed a request. We used the same law that we're not abiding. So we filed a request to every municipality, to every agency. In terms of the agency, 25% of the 121 agencies in the government of Puerto Rico named their public records officer after I sent a FOIA request. It's just like, oh, we got to do this, then they filed it. Since they were supposed to give me the letter officially naming them, we were able to compare to see the dates they were named. And in terms of the municipalities, 64% of them named them after we made the request. We had to go to court and sue 17 municipalities who had failed just to name who's the head, who do you send a public record request to. That's all we wanted to. Give me a name, give me an email address, and give me a phone number. The basic, democracy, bureaucracy. And, they all complied after they were sued. So that number is up to 90% now of the public records officers were named after we filed this strategic litigation, which is mind-blowing, and that just having the person you need to contact to were named. they didn't the finding their contact information is almost impossible on their websites. If you go to a municipality in Puerto Rico, usually they don't have website, they have Facebook pages. So even if you want to contact the mayor, you got to go to our Facebook page. So we created a directory with the information of other public records officers. This was done with the pro bono help of law students at the Inter-American School of Law. This is their service to us and to the people of Puerto Rico. And we have now an updated agency and municipality directory. They're on their website, but if you want to know where they are QR codes that you can use it. But this took a lot of work, and it's incredible that we're doing the government's work just to have access to information. In terms of the deadlines, going back to the law, before Act 141, the government had no legally binding deadlines to respond to requests, and Carla can comment about that. Months waiting for a report, for statistics, anything. Now they have a deadline, 10 business days, to respond and produce. This is a production deadline. It's not an acknowledgement of receipt. They have to produce the information. It's 15 business days if it's a regional office, and they can extend it for 10 additional business days, provided that they give a justification and inform the requester within that original 10-day period. I think this is very positive. Journalists don't like it because information that used to be easily accessible before, now the default is like 20 days, you know? Maybe there was a press conference and they gave a statistic and you want the report that they use that, then you file the request like, no, I'll give it to you in 10 business days. I'll give it to 20 business days. So this helped. There were agencies whose bureaucracy was horrible. This, put them in check. But then there are other ones that they want to hide things or want to have the press wait. Now they use this as an excuse to delay disclosing information. But under the law, those are the deadlines that we have now that we didn't have before. And failure to respond, whether in the original period or after the deadline, is considered a denial. So you have standing to go to court after 10 business days if they fail to respond, which, you go to the specialized courts, it moves very fast. And every denial must have a legal basis. This is confidential because this law says so. This is private information. It's protected under FERPA if you're asking something at the Department of Education, for example. All right. Cost, regulations, and interpretation clause. I told you about the fees, research, review, and everything under FOIA. In Puerto Rico, under this law, is a general rule. It's permanent and free of charge. Reasonable fees can be charged only if it's like a certified copy, recordings or reproductions of videos, for example. But we know that very recently agencies, they're not doing it with the press. They don't like to mess with the press. But other activists and civic organizations, especially environmental activists, they've charged up to $500 or want to charge $500 just for getting the entire file of a permits process of an area that has been highly impacted, it has potential environmental impact. And just to give you the file, they want to charge you $500 if, we've gone to court and we fought it. So this is one of the fronts of litigations now coming up, are the costs. The same with regulations. One of the problems with the law is that it allows agency regulation, to add additional requirements. Now they're requiring specialized forms to give your identification, to certify what you're going to do with the information. And every agency has its own little book. So now it's getting a little bit more complicated, and we've been going to court dealing with that. One of the good things that we have is there's this interpretation clause that says any regulation, any law that conflicts with this general law and the constitutional right must be, the interpretation must be liberal and the most favorable to the person requesting the information. And I've used this clause many times to win cases in court when they try to restrict access to public records. So this is a positive thing from the law that we have an interpretation clause right there. Okay, so I talked about the writ of mandamus, which is the classic mechanism to go to court. But Act 141 created a new, what's called a special petition for public records disclosure order. In general, there are no administrative appeals compared to FOIA. You go directly to court when you are denied access to public records. This special petition can be filed if you're denied the request or fail to respond within the deadline that I mentioned. This request can be filed self-represented or pro se litigant. I don't recommend it. We tried it, we endorsed it for a while, and it's very complicated, and I'll explain why in a second. There's a form, there's a lawsuit form, a template the judicial branch made. We don't think it's a good one, so we made our own. So we have our own lawsuit template if people want to file their own request. You must file this special petition 30 calendar days after your last communication with the agency, and if you do, it's free of charge. There are no filing fees for this lawsuit, which is very positive. Even attorneys use this if they want to pay for filing fees, which would be otherwise be $90 to file any lawsuit, any civil lawsuit in Puerto Rico. And the government has to answer its complaint within 10 business days. The judge may hold a hearing within 3 business days, and the court has an obligation to resolve within 10 days after answering the complaint, after hearing after having the hearing, which is in theory good. Have you heard about another civil complaint that can be all done and in 2 months? That's insane. It usually takes a little bit longer, but we've had cases, in a month, 2 months, 3 months tops, which is very positive. There's no discovery. There's a presumption everything's public, so it's the government's job to try to say why it's confidential. The production and post judgments part of the litigation can be long, especially if the request is very voluminous, and that's it's a large production, and journalists usually have huge databases. But in general terms, things are moving faster. The criticism for self-represented and pro se litigants procedures in Puerto Rico is that now, and we were in a conference a few months ago here in Orlando too, and it's happening in Florida. You have electronic filing for cases. In Puerto Rico, only attorneys have access to that electronic filing system. It's not like PACER at the federal level that any person can open an account and see what's happening on PACER. Puerto Rico, you need your bar number to open that. So, if you're a pro se litigant and you file the special petition, you can only file it in person at the clerk's office. You can receive notifications from the court and the judge via email, but you can respond via email. So if you got to reply to the complaint, you got to go back again in person to the clerk's office or send it by regular mail, and then the judge can decide. There was a pro se litigant that I was assisting, and he almost lost his case because he lived in Vieques. And he was answering or replying or opposing a motion to dismiss, and he had to send it by regular mail during Christmas time. It almost didn't make it, and the local DOJ asked for the case to be dismissed because the opposition wasn't there. And we're talking about a pro se litigant who has a constitutional right to access the public records that he was asking for, which involved police brutality against himself. So. Unfortunately, he lost that case, but after that experience and many others that we've had, thankfully, and I'm going to talk about the clinic that we work with, we try to recommend people to go to the clinic, because until they fix those procedural aspects of pro se litigation and the special petition, it is really not worth it. So here's the guide that we launched last March, and that we translated into English for this conference, and now available for everyone. It's on our website live right now, and it gives you, step-by-step Q&A style, and non-legal terms, but it has legal information, what I just talked about, how to file a public record request in Puerto Rico, and who to contact if you need help from the most experienced attorneys in these aspects in Puerto Rico. And we also have the templates that I talked to you about. They're currently in Spanish. But you can file lawsuits in English in Puerto Rico. So I'm working on the translations for the templates moving forward. Next project, because we really want to have accessible to people that don't live on the island. If you want to have a file records request and you don't know any Spanish, that you have a template that you can use to file public records, and use to our favor the fact that we don't have a residency requirement like other jurisdictions. And then I just want to mention, the Access to Information Project Clinic. Their email is right there. You can follow them on social media. They're a great group of attorney Luis Jose Torres Asensio, Stephen Lausel, the great Judith Perkin, who we're going to talk about now that we get into the litigation against the Fiscal Control Board, and attorney Jeffrey Martinez Aguilar. They're great. CPI couldn't do the work that they do if they didn't have the support from this legal aid clinic, and they're an instrumental part of our team. They're my mentors, and I just wanted to give them a shout out, because I'm here also in representation of the work that they do and they've been doing for the past 15 years. All right. So now we're gonna talk about the two cases, or most experienced litigation with Promesa and the U.S. Treasury. What we're gonna do is I'm gonna give like a background summary of what happened, where we at the cases, and then I'm gonna go back to the seat and I'm gonna have a conversation with Carla from a journalist perspective, how these cases came about. Promesa, Puerto Rico Oversight Management and Community Stability Act, created the Financial Oversight and Management of Puerto Rico, 2016. Promesa states Promesa is federally appointed body, but the board is, and this is text from the law, is within the territorial government. So for all purposes, it is considered in almost like an agency of Puerto Rico. It's paid by Puerto Rico taxpayer money. Okay, federally created, but it's paid by Puerto Rico taxpayer money. And it oversees the debt restructuring process and allegedly seeking to return Puerto Rico to the financial markets and fiscal stability. All right. Even though it's federally created, but it is a Commonwealth entity, it has a jurisdictional provision that any action against the oversight board must be filed in the U.S. District Court in Puerto Rico. So you have to go to federal court to file a lawsuit against this federally created Commonwealth entity. All right. The law has a supremacy clause, which preempts any local law which is inconsistent with Promesa. And as you'll see, that also includes constitutional rights that are inconsistent with Promesa. And the law says it clearly. You're not a federal agency, you're a Commonwealth entity, so the Freedom of Information Act does not apply to the board. It says so explicitly. The Federal Freedom of Information Act. So what happened? When we saw the provision that said within the territorial government, we said, oh, so you're subject to the 1982 Puerto Rico constitutional right of access to information. So in 2017, CPI sues the board in federal court, because that's where the law says us to go, under Puerto Rico's constitution for communications between the board, the Puerto Rico government, and Congress about its policies and operation. We just wanted to know, what they were considering, what are their policy goals. We just wanted to know everything that they were doing. We'll talk about the request in more specific way. We talk with Carla. The board opposes, arguing that Promesa conflicts with the Constitution, a preemption argument with the supremacy clause, and claims, and this is very important, state sovereign immunity protection. And sovereign immunity, just a refresher, a ruling government or its body has the option to choose immunity from civil lawsuits or criminal prosecution. You can be sued without your consent. It comes from the old saying, the king can do no harm, or in this case, the imperial board can do no harm. But there are two different kinds of sovereign immunity. And the source of where that immunity comes from is very important. And this is where I'm certain that the U.S. Supreme Court got it wrong. The 11th Amendment is for the states. You gotta be one of the United States. That's what the 11th Amendment says. So for us, it was and as part of our argument, that the board was using 11th Amendment immunity when Promesa exists because of the territories clause. It is not one of the United States. So that's 11th Amendment. But then there's also called inherent immunity or common law or foreign nations immunity. The U.S. and other foreign nations can be suing one another. There's specific federal statutes that allow for that, but you have that immunity because you can't be sued without your consent. So we don't know what kind of immunity Puerto Rico has, and the U.S. Supreme Court decided not to get into that question, which is for us a threshold question to be answered before answering the problem. But that's it. We got preemption and we got sovereign immunity. If you're invoking 11th Amendment sovereign immunity, and this happens for federal laws, tribal nations, for example, and one of the biggest cases, the rule that the court has used is a clear statement rule. Any act or statute that the Congress enacts must express its intent to abrogate any state sovereign immunity clearly. If it's not clearly, that state reserves that residual immunity, when you join the union, you give some, it's all fictitious, it's all legal talk, you give some sort of sovereignty to the federal government, but you retain some residual immunity, and if Congress wants to abrogate that immunity that a state reserved, it has to be clearly stated in the law that it approves. So it's important to have that in the back of our head, a clear statement rule. what happens? Here's a picture of attorney Judith Birkin, which has been the lead attorney in this case. She's a prominent civil rights attorney in Puerto Rico since the 70s. She's amazing. She has created a lot of important cases with other sort of qualified immunity and discrimination, and she's on the board of CPI, and she was the head litigator in this case. So we followed the case, and we win the first time around. A judge in the U.S. District Court said, you know what? Promesa abrogated any sort of immunity that you may have. There's this whole judicial scheme. You go to court. It makes no sense if it didn't abrogate immunity. Preemption, it doesn't conflict with preemption. The Puerto Rico Constitution is a right, and it goes around it, and the board starts producing records. 18,000 pages worth of records, which we're going to talk about at the in the conversation. They start producing. Then all of a sudden, 2020, they stop producing records. Because what happened? The case was referred to a magistrate judge, and they needed to file a privilege log. And they got to give justifications for why they were redacting information. And they didn't want to give explanations for the things that they were redacting. And you'll see from the emails that they produce, the sort of things that they were producing that they want to hide. So they stopped disclosing, and CPI files a second lawsuit asking for the same records but extending the period of time. Because at this time around, the original had a cutoff date of a year. And it was like, no, we want a second. We'll start moving the case, and we'll have all the information that we're requesting until the final day of production. So we extended the scope of the records that we're requesting. At this time, the board files an interlocutory appeal. The only reason, because the public records for FOIA case, that you have a final judgment when the production ends. So there wasn't a final judgment in this case. It's procedurally a very weird case. So they file an interlocutory appeal, because if you have a constitutional claim, like an amendment claim, you can go up to the First Circuit Court of Appeals and litigate that specific issue. We opposed it, there was an oral argument, and we won the case 2-1, saying, you know what? Promesa abrogated that sovereign immunity. It makes no sense that you have it, and they can go to interlocutory appeal, whatnot. But there was a very strong dissent saying that this is going to be mayhem for Puerto Rico. Bondholders are going to start asking public records. This was the whole entire debt restructuring process was going to go crazy, because everybody was going to know what was happening, internal workings inside the board, and the board need to do their job in secrecy to get Puerto Rico safe into, back to fiscal recovery. All right. The board files a cert. SCOTUS, we oppose it. That is not common in Puerto Rico Supreme Court, but we oppose it. And to our surprise, the U.S. Supreme Court granted cert. I don't know if you know, but they see 88 cases a year. It's only 1% of the cases that they see. We couldn't believe that they were going to see this case. The question presented was statutory simple. Does the language of Promesa abrogates Puerto Rico's sovereign immunity? The board said no. There's no clear statement rule. It has to say it so. Promesa doesn't say we're abrogating Puerto Rico's sovereign immunity like it says in other statutes that have to do with tribal, with the Native American tribes. But Puerto Rico said yes. Our interpretation is there is a clear statement rule applies. But regardless of whether that rule, you need to decide first whether Puerto Rico as a territory colony enjoys the same sovereign immunity as a state. Because you've been asking, you've been litigating this since as an 11th Amendment state sovereign immunity from the beginning. Okay, so you gotta decide what is the legal and historical source of that immunity before you can decide if it's been abrogated or not. It makes no sense. That's a threshold question. And we even had an alternative argument. The Puerto Rico government has consented to be sued in access to information lawsuits since 1982. Otherwise, the board will be, and that was the effect of the decision, the only Puerto Rico Commonwealth entity not subject to any public records information statute, not FOIA, and not Puerto Rico's constitutional right if you decide otherwise. We had a lot of support, the amicus briefs, 30 organizations, 19 law professors. I work very closely with the case. I was the liaison between, and I'm going to show later, our pro bono representation in D.C. and Puerto Rico. But the Biden administration sided with the board. They requested vacatur. So, this is not about partisan issue. Clearly the permanent position of the federal government is, the board can do no harm. That is basically their position. They were put in place there to do something. This is us in oral argument. We had pro bono representation by a great law firm in D.C., Williams and Connolly LLP, are the attorney who argued the case for us. Sarah Harris, former clerk of Justice Thomas. And then we also had Lisa Blatt. I don't know if you know Lisa Blatt. She's the woman who's argued the most cases before the U.S. Supreme Court. She was clerk to Justice Ginsburg. So, we got from both sides just to make sure we wanted to win the case. Oral argument was, I was there since I signed the brief and I was admitted to court. I was able to sit in the attorney's chair right there. So I was right in front of the justices. I couldn't believe that after, that getting this fellowship would, get me all the way there. I had my Puerto Rican flag with me, just if they saw, remember what's happening here. It was very crazy too, because it was on January 11th, which is the day in Puerto Rico that we celebrate Eugenio Maria de Hostos. So there was a lot of coincidence. There was a very cold morning, and it was crazy to be there. But argument happened. It was very fast. Then we had like a lunch and we talked about it, and shortly after, an 8-1 decision came down, and the court did not answer the threshold question. It assumed, without deciding, that Puerto Rico has sovereign immunity. We're not going to say if it's 11th Amendment, if it's common law, inherent, foreign nation, no. It's assumed. You're a democratic government. You have sovereign immunity. We're not going to get into the source of that immunity. Justice Kagan wrote the decision. It says that Promesa did not clearly abrogate any immunity. We got one vote. We got a dissent from Justice Thomas, who said there was a threshold question to answer. I would have ruled in CEPI's favor. And that's it. And as the result is, the board cannot be sued under FOIA or under Puerto Rico's constitutional right to access information. No transparency in the board's operation. And then the other case, and then now we're going to discuss it more in depth, but the other case it's parallel to this case, it's a FOIA case against the U.S. Treasury, because the U.S. Department of Treasury played a central role, as they admitted it in court, during the selection and appointment process of the Fiscal Control Board. During the Obama administration, he delegated the selection process of the board members to Treasury. So in 2019, CPI, with Latino Justice and Center for Constitutional Rights, submitted a FOIA request, in essence trying to figure out what were the selection criteria for the board members, who was involved in the selection process, how were they evaluated, was there any conflict of interest policy, like who was being appointed to this board, do the people being considered had any connection to Puerto Rico, if they're going to be the de facto rulers, and we just want any discussion or email exchange that from this time period. In May 2019, we filed a complaint in the Southern District of New York, and I must say this is a case co-counsel with Latino Justice. Leah Fiolmata has been spearheading these efforts, and I gotta give a shout out to her because this is a work that we're doing jointly. But after 4 years of production and negotiations, we got 2,798 responsive records, mostly heavily redacted, like this one. But they tell us what was this about. These were the candidates the creditors submitted to become members of the board. So we already know from the get-go that the creditors the board is supposedly bring us back in a healthy debt restructuring process, but they're consulting with creditors. The creditors. They mostly rely on the deliberate process, on right invasion of privacy. We negotiated a lot. We reduced the production. They disclosed a few things. They gave us a few things. But we're challenging around 90 records right now. What we're mostly challenging right now are the list and the background information of the unselected candidate who was considered for this first board. And we'll get into the details of what they've been arguing in court. But now I just want to sit with Carla and have this part of the conversation as a discussion from both cases, from both my journalist perspective. This can be a more open conversation so we can get the questions part of it.
Yeah.
So the first thing that I wanted to talk with Carla is about the board's case. that made it all the way to the Supreme Court. What were the expectations? What was their request? What were their journalists looking for in this case?
Well, we had gotten about 15,000 emails from the first part of the case, and they had said that there were another 20,000
20,000, yeah.
emails that they were not
Disclosing,
disclosed during the first part of the case. So we were looking for those 20,000 records, which were basically emails, attachments, reports, and that kind of document. So yeah, we thought that since the first round of emails
yeah,
allowed us to do a few important stories about how Republican senators were pushing for the privatization of PREPA, of the energy company in Puerto Rico, and we were able also to understand how
consulting agency McKinsey,
companies like McKinsey in Puerto Rico were the lead advisor, and while they were being
signal out.
Signal out for having conflicts of interest. And we were also able, I think basically what we got from this first batch of documents was the tone in which the U.S. government agencies like Treasury, White House, and the Congress were relating to the board. The way they were speaking to the board, the way they were giving instructions to the board, like if that was not an independent body doing the fiscal reorganization in Puerto Rico. The tone, the way.
I'm going to show one of the emails right here. We have two. This is from the first production. When we got the first round of documents, we got this message from Senator Flake's office talking to Andrew Biggs, who's one of the members from the board. First of all, familiarity. Andrew. The Flake and Lee offices have quietly been kicking around the idea of legislation to implement PREPA privatization that the members of the board have advocated. We're pretty new to PREPA game, and we're wondering if we could grab a few minutes for a phone call with you to get some background on what we're thinking has been done and how to do this, Chuck. They're very involved in the privatization, and then they're making the decisions, and so we have what I call the imperial SARS ruling over Puerto Rico, unelected body, and supposedly there's supposed to be some independence from the way it's happening, but they're constantly communicating with the members of Congress. And then the other email, it is to another member, Carlos Garcia, and this has to do with the creditors. First email, started engaging with creditors yet? They want to make sure that creditors get paid. So they're sending emails from the Congress just to make sure the creditors are getting paid. Yes, a lot of focus on GO general bonds and COFINA controversy. Each group stepping up their rhetoric. Board pressing on for meaningful progress. Challenges the limited projected primary surplus. Should know more by next week. So they're completely connected. None of the major creditors have said you guys have been in contact. What discrepancies here? So we have a member, somebody from Congress or from creditors. It's it's a circling. More than a conspiracy. It's a revolving door. It's a revolving door. That's what it's called. That's the term in terms of corruption. It's revolving door. Everybody's. We're all friends. Yeah, I want to help you. You want to help me.
Yeah, but also there is like this tone in which some people feel from the federal government that they are entitled to get information and details about what's happening in Puerto Rico in a bankruptcy case that probably not even the Puerto Rico government had access to. So, it's this colonial relationship operating, in a very raw and blunt view. So since we got these kinds of communications from the first batch of documents, we said the rest 20,000 should be gold.
Juicier.
So
And
that's what we wanted when we, decided to.
And there's when they stopped producing, and we're gonna fight this all the way, and they made it all the way to the Supreme Court.
And that fight started immediately after we published these investigations.
So you gave us the first batch. We published this, and it's like, okay, we're not gonna give you any more. This is gonna be horrible. Let's gonna keep up fighting. And then so what are they hiding? Look at the things that they're hiding, and I think why does it matter? The CPI has written about this, but you can mention about board, what we call the silent expansion of fiscal control boards throughout the United States. Promesa is just an experiment. Promesa doesn't apply only to Puerto Rico; it applies to every other U.S. territory. So who knows who's next? I think Guam is having some financial issues, and has been mentioned that it could be applied there too. And in terms of municipality and state, the Detroit had his fiscal board. New York had the first one in the 70s. So, but there's been a silent, this is a new way of controlling.
A silent expansion of these, they have different forms and names. Some are emergency managers, some are boards per se, but is essentially the idea of a group of people or a person who takes over the financial aspects of in our case, a country, or a state or a city. I think, from our research, Puerto Rico board has been the most extreme, but it sets a precedent too, for other new control boards. Because there are people who argue that this has done good to the public finances, and of course there will be arguments made about how this contributed to Puerto Rico's recovery, even though this happened at the same time Hurricane Maria and Irma happened, and all the federal money coming in the next years would be difficult to
separate.
What
was the impact?
What was the real impact of the
austerity
board?
measures, or was it the influx of federal funds after the disasters? What led us, or was supposedly leading us to recovery? So that's part of the analysis to be done in the future in that regard.
Yeah.
And then I also want to talk about a little bit about the consequences. It's a journalist organization. The fight is not over. We're always looking ways to keep fighting. The thing is, we filed a lawsuit at the same time, the same day that we filed the lawsuit against the board in federal court. We filed one at the Puerto Rico court against the Puerto Rico agencies, because if they're sending messages, email communications, there's a sender, there's a receiver. So maybe we couldn't get the answers from the board, but we can send the messages that the Puerto Rico government was sending. And that case was seen in Puerto Rico courts, and we won that case. They made it all the way to Puerto Rico Supreme Court, and they have to produce. And they started producing last year, rolling production. We have more than 12,000 pages of responsive records of emails. Sometimes we get communication with consultants. So we see the Puerto Rico's government perspective of their communications with the board. Obviously, we're not getting the rest of the communications with members of Congress, or other federal agencies, or even
boards, contractors.
Oh, boards. So there's a part of the universe of communications of the way that the board operates that we're not getting, but we're getting something, and that's a big rolling production, and then there are some hidden gems there. That I know that reporting is being done, that coming soon, but then. The problem of the board not giving access to public records, it goes beyond a journalist's perspective. There's this organization or company called Media Waters Project Netherlands, and they describe themselves as an efficiency-oriented water operator who were bidding in Puerto Rico for a project, RFVP, Private Public Alliance. It's a commercial request. They're trying to get cell services to the government of Puerto Rico, and they didn't win that RFP, and they wanted to know why. And they saw that Puerto Rico has a public records law, and they filed a public records request to the board. We know that you're the ones who's deciding where the money gets cut, who gets the contracts. We know that. So we want to know why. So this is not journalism. This is a commercial request, and the case. But they wanted to do something different from the Puerto Rico case. And they said, you know what? The case will stay pending the U.S. Supreme Court decision. But they only use Act 141, 2019. Because Act 41, 2019 clearly states it applies to every government entity. Because one of the things that the board is arguing, it's not clear that constitutional right that you're talking about, that's jurisprudence, whatever, whatnot. But they decided, we're not. It's recognized under a right, but we're going to use this law. And this law is from 2019. You've been here since 2017, and you've opposed other laws implemented in Puerto Rico and vetoed them. But you didn't veto this one, so you are subject to this law. That's why for us it's important to discuss the other act, because this is the source that this company is using in federal court to argue this case. It is currently at the motion to dismiss stage. It's been completely filed. This is under Judge Pedro Delgado in the Puerto Rico U.S. District Court, and to see where it goes. This is a sequel of our case, only under the Transparency Act, and they're arguing everything: preemption, inconsistency. They're even saying, if as an alternative reasoning, you gotta nullify Act 141, 2019 Transparency Act. So we'll see what that goes, but this is one of the consequences. And then there are other organizations, Espacios Abiertos, which is a close ally to CPI. They're a financial transparency watchdog. They crack the numbers, and they after our decision, they filed a request asking for data about the restructuring process, and they just really wanted to know the expenses of the consultancy, the McKinseys of the world, and the other ones. We wanted to know how much money you're spending on them, and they flat out rejected it. No, this decision came out. There's no need to give, whether it's the press, whether it's a private corporation or a watchdog nonprofit, they decide when they give information. Everything else is going to be secret. One of the things that that keeps worrying us is the fact that the new chairman of the board, says that he's happy. There's a lot of work to be done. It might be 5 more years that they're here. It's not even what Promesa says. It's when the budgets, you have approved budgets that are equal for X period of time or whatever, adjusted. It's like there might be other reasons for them to stay. So we might have the board, who knows until when. What could be done? We've always discussed the possibility of amending Promesa and making sure that it will be retroactively, but that requires some sort of policy work, which is very hard. Promesa has been amended after the fact because of the ethics concern. Part of the reporting that CPI did about conflict of interest moved a congressman, I don't remember who presented, and they proposed a bill and they amended, and they now have to give more conflict of interest disclosures. The other thing is actually amending Act 141 2019 just to make sure that it explicitly applies to the board. But we'd see what happens after the other case. But this is what we're dealing with. These are the results of the only government of Puerto Rico entity who is not subject to public records law. The CIA. You can file a record request to the CIA, to the president, to the FBI, but you can't file it to the board. Which is absurd. Yeah. Go to the Treasury case?
Yes.
Okay. So the Treasury case. This case, there's a lot to be talked about because, the production, the first thing that I wanted to ask Carla is, this was the goal for the first request, selection criteria, who was involved. And I think we have an answer to most of these questions by now, but I'm going to let her go over them.
Yeah, basically, one of the first public meeting, during the first public meeting of the board, the president, Jose Carrion, said that the members of the board were
they went through a rigorous process.
They went through a rigorous process of selection, and yeah, that like you can confirm that. He said something like, this can be confirmed. So after, when we covered that initial public hearing, and when we got out, we said, okay, we want to know that. We want to know who did this rigorous process, and how was it, who was involved, and what was the criteria. So we did this, request with these kinds of questions initially to the White House. The White House sent us to the
National Archives.
National Archives. They then sent. They said they had nothing
About the rigorous process.
about the rigorous process, and they ended up referring us to the Treasury Department. This was like months after we got, some reaction from them. So we went to the Treasury Department. We asked for the information, and then they said, "FOIA me." So we did.
So the first thing, selection criteria. Were there selection criterias for the board members?
Did they had to be Puerto Ricans or had any relationship or context about Puerto Rico? Did who was involved in the process? Was only Treasury, or were there other or other areas of the government? We knew there were different lists, some of them coming from Congress, from the Republican side, some of them coming from the Democrat, and some of them coming from the president itself. But we didn't know who was in which list.
And then we found out that creditors were recommending, labor unions were recommending, a lot of people had were involved, because Promesa requires that the president makes the final selection, but he uses a list that comes from different parties and from the Senate and the House, things like that. So we knew they were going to be involved, but we didn't know how and who was influencing them with that sort of list.
What we didn't see was a list coming from Puerto Rico
Never.
government or Puerto Rico organizations,
So-
or Puerto Rico Academy, or Puerto Rico economists, or Puerto Rico people.
Nobody from the island was involved in this selection process, completely imposed in that sense.
So in terms of how were they evaluated, we now know that basically they were not.
Basically, they were not.
They didn't have a standard guide to evaluate these persons, like checklist of things that they had to, they didn't do the same kind of approach or interview or set of questions or documents request to every person.
No, they mostly interview those who had potential conflicts of interest. They want to make sure that those revolving doors that we talked about, there was the ones who interview. Other ones, if there's no problem with you and you fit whatever criteria that we're looking for, you're going to be there. I'm going to show you the charts. Don't worry. You're going to see the only criteria that they had. In terms of the conflict of interest policy, there was...
We know there were conflicts of interest, preoccupations, because in the emails they are using these words, but we don't know in the end what were those conflicts.
Those are heavily redacted.
And how they came about to be sure that there was that was not an impediment for them to become part of the board.
Yeah. Connection to Puerto Rico, you'll see that part that says Puerto Rico ties. It is very, maybe they were married to somebody from Puerto Rico and that was their tie, or not even, maybe no ties, and it didn't matter. And we got a lot of email discussions. So that's... Okay, so let's see a few of the things that were happening there. So the first thing is, I want to talk about what their claim exceptions. There were they had two things. Exception 6 is unwarranted invasion of privacy. We can't have access to potential candidates to the board because we're invading their privacy. Because individuals who were considered for positions on the board, some of whom may not have known they were being considered. So you have an expectation of privacy even if you don't know that you're being considered, and may still not know to this day, they weren't considered. So you can't have those information. And then this is the one that this is admitted in a court file. Given the controversial nature of Promesa after the fact, and the oversight board in particular, disclosing the withheld information could result in embarrassment and reputational harm. So we can't give you the list of the people that were considered because they will feel embarrassed. They were considered for the board. And we know there are people who support the board. There's a contrary argument that could be made. But, the U.S. Treasury Department explicitly admitted this in a court record. And here we can see, the spots. Ryan, who was the speaker there, McConnell's spot, rank order, because they ranked them in order, the ranking order from the Democrats. We know the Democrats had labor candidates, the progressive folks, restructuring experts. They also have you can see it right there, but it says pinch hitter, all around qualified. They had different candidates. That's how they referred to them. And then in terms of the deliberative process privilege, which deals with internal agency communications, they can't give us the names, just the names, or the background information. I was going to show you another chart right now, because the mere fact of gathering information, even if it's publicly available, if you took somebody's CV or you went to their website for the company they worked before it and they compiled it and put into a list, and that's how they're going to identify a candidate, that mere act of gathering information is covered by the deliberative process privilege, which is absurd in our position. Obviously, we have case law that support that. So this is an example, and then so their position, our position, contrary to that, is in terms of privacy, public interest definitely outweighs any privacy interest if they have any, because they even didn't know they were being considered. And in terms of exception 5, it's clear that if it's purely factual information, it's not deliberative, and it can be segregated. What I talked about, And since we entered in negotiations with them, they unredacted the information of the members that were ultimately selected. So we have an idea what is the kind of information that they have for those that weren't selected. So we have here David Skill, the president of the board. You can't see it very well. Let me see if I can move it or something. But it says bankruptcy and legal expert. You can know that from, he was a professor at UPenn Law. You can find that on his website. The rest is just his information. He's a professor at UPenn, authored of books, received an award 3 times, and that's it. That's factual background information. So our argument is that's the same information from the ones underneath, and we don't know who that person is. So there shouldn't be any privacy, because there is nothing embarrassing about knowing your CV, and obviously you got to prove that that public interest a little bit more. And we submitted sworn declarations, one from Carla and one from journalist Luis Valentin, who's the journalist in charge of most of this investigation. And he put it out simply, what is the best way to describe the public interest in this case? Whether the selection and the appointment process was skewed by design from the beginning, with a pool of candidates that favor similar interests and policy-oriented views. That's a clear public interest, to know what the government is up to, which is the purpose of FOIA, and then obviously with the embarrassment part, this is from Carla's declaration, any unpopularity, outcry, criticism attributed to the Fiscal Control Board, and even the embarrassment for being associated with it, can be directly correlated to the central role that the agency itself played in execution of Promesa. You can't disinherit your own creation, is the way that we put it in our filings. The case has been submitted, fully briefed, motion for summary judgment. We'll see what comes out of that. And then this is the other list that we wanted to show you, because they release information of those who were selected. That was part of the negotiations. So we got the candidates, Democratic name, the source, HR, NP, admin. NP, we said that's like, I think it's like Nancy Pelosi, might be Puerto Rico type, diaspora, wife on the island, Puerto Rico party, independence, Partido Popular, gender, expertise, government, finance, background, CEO, retired bankruptcy judge, the Republican side, connections to the island, none. Source, MM, we're guessing that's Mitch McConnell. PR, we're guessing that's the current governor, Pedro Pierluisi, who was a resident commissioner at the time. Runs insurance brokerage, bankruptcy. So we're saying, once again, this is not an invasion of privacy. This is purely factual information. And you should unredact those things. Those are the things that we're fighting in court right now. But look at how they reduce the selection process for the people who basically run Puerto Rico right now. Why does it matter? Puerto Rico's residents on the archipelago who do not vote for the board members, the members of Congress who recommend them, or the president who appoints them. We have a right to know who they are and who was considered, because we're now in the second slate of board members. We've said the current chairman says, president, that they're going to be here for a longer time. So there are going to be more appointments. Are they following the same process? We remain in the dark about the selection process and the identity of the most powerful government entity in Puerto Rico today. The board will continue to operate, and we don't know for how long. And questions continue to be raised about institutional affiliations, background, and conflicts of interest of potential and current board members. So that's the other parallel case that we're having. Hopefully, the judge rules in our favor. We're hoping on that. All right, just to end, and then we'll open up for questions. We wanted to have some practical notes in terms of, you want to submit a public records request in Puerto Rico. Research the agency website to know, if they've changed the public records officer, or use our directories, use our templates, our guides. They provide the best directions for filing a request. We always say to avoid writing an unnecessarily broad or specific request. That sounds like a contradiction, but an agency would use whatever they can to deny a request. So maybe it's too broad because you're asking for a statistic about violence in Puerto Rico, but you're not detailing which misdemeanor or act of crime you're identifying. We also say identify the specific dates or places requested. That is very good to narrow down the decision. I want statistics from March 2022 until, instead of saying until the present, until the date of production. We've learned that from our experience, because they might start producing a few months afterwards, and something important happened in that time period. We always say be careful with follow-up messages, because at least from the perspective of journalists, since they're using the business days deadlines against us, they were like, oh, you sent a follow-up message, that starts the clock again. 10 more days. So just be careful with the follow-up messages and the deadlines. And sometimes we've calculated, we have the date they're supposed to produce, and the journalists count a date that wasn't, and they use that in court. It's like, no, this I have more time or less time, and they'll do anything not to give you records. And this is very important. Sometimes an agency might say, we don't compile that. We don't generate it. We don't keep a record of that. And we always say, but ask for official certification under sworn statement by the head of agency. And when you ask that in an email, they start responding. Then you sue. And when you go to court, it's not the same certifying, sworning in front of a judge that you don't produce that information. That's just saying it on an email. And sometimes they do, and then we find out that they do keep it, and that's a whole other issue. But you always be careful with that in that general sense. And if you don't understand a database, you always say ask for a key, a data directory if needed. But we have a lot more tips on our guide. It's right there. It's available. Anybody can be a citizen journalist. Everybody can oversee the job in Puerto Rico. That's the way that we see it. I told you at the beginning, this is a constitutional right that came from a citizen claim from the parents that were seeking justice for the two independent students murdered at Cerro Maravilla. The press uses it more, but this is a citizen right. So, and as attorneys, you can help people with their problems, or you can also file that for your clients. Thank you for attending. We can open up to questions. We want to talk about anything, but thank you for your time.
And your love of the Puerto Rican people in Puerto Rico. Thank you.
Thank you.
Let me add, this was a marvelous presentation, Carlos and Carla. Absolutely marvelous. I learned so much. I never realized this area of the law was as complex as it is. And I'm not really sure I wanted to hear all that bad stuff. If I was pissed off before, I'm kind of pretty angry now. But I'm so glad that you participated here and to teach us all about this particular area of the law. I want to note to all of us that this is being recorded. This course is certified by the Florida Bar for CLE credits, and we will be distributing it to the 90,000 Florida lawyers that they can hopefully take this course, take this class, and learn something about Puerto Rico, which is the purpose of this conference from the beginning. So thank you all for making it present. Thank you guys for making that possible.
Does anyone have any specific question or concern or reaction to what we? There. Okay.
She has
Please use the microphone so they can record it in the.
You can
Okay.
go first because you have the microphone.
Okay, I'm going to speak Spanish. I'm sorry, but quiero dar las gracias. Yo vivo en Puerto Rico actualmente. Estoy muy agradecida por toda la información que he recibido, que estando viviendo en Puerto Rico no sabía muchas cosas de las que él explica. Así que nos abre un poco la conciencia y nos da más claridad de lo que realmente está pasando y de lo que uno puede aportar en ese, ¿verdad? De ahora en adelante, principalmente el hecho de la transparencia de los documentos, de las facilidades, de cómo nosotros podemos acceder a enterarnos de realmente lo que está pasando. Así que gracias, ¿verdad? Por toda esa información que va a ser de mucha utilidad. Gracias.
Gracias.
Yes. Yeah, I was just wondering if you could speak a little bit about the recent departure of Justin Peterson and some of the comments that were made public on his departure that might have shown a little bit of his conflicts of interest.
Yeah.
Leave that to a journalist.
Yeah, Peterson's tenure was so brief that we didn't get to do a lot of accountability reporting around his work. We did during the last 6 months. We did some requests about conflicts of interest filings because they started a new process in the board for the conflicts of interest, how to solve conflicts of interest issues that arise from contractors or from board members or employees, and they have an ethics consultant, a permanent ethics consultant at the Fiscal Control Board that is supposed to go over those conflicts of interest issues. But we have no information. There is no report being done about the results of those evaluations. We are guessing Peterson, some of conflicts of interest issues were evaluated by this ethics person, but we don't know what she evaluated and what was the result of her evaluation. So we are blind, completely blind about that.
Even like that, the law was amended to get more procedures, and there were
Too little, too late.
Too little, too late, and our journalist Luis Valentin, even after the Supreme Court decision, they went to one of the last public meetings, and he was the last one to ask questions because they usually leave at the journalists from CPI to the last, or they forget about us at press conferences, and he asked a question. Okay, we know this happened at the case, but I'm here now. We're in a public meeting, so I'm going to ask you about conflicts of interest. And they just referred him to the attorneys, to the board's attorney. The president said something, that didn't make a lot of sense. It's like, our attorney can keep talking. And it was like, yeah, we don't have to answer that because this seems like a request, like a public information request, and you're not, we're not subject to it. So everything that we might know is, because we journalists at CPI like to talk in after they, review the facts and the reports and the forms. So we're in the blind again, in the dark, in that regard.
And they could decide, even though, they don't have to comply with our records request, like officially. they could like improve their
yeah.
transparency standards
Voluntarily.
voluntarily, just for the sake of it. But they haven't.
Yeah, because if governments understand that transparency, accountability, it gains confidence from the public. You know, it is a win for them. You know, transparency is always a win. It's a key pillar of democracy. But they don't see it that way. You know, they're transitional, secrecy. They have other interests that are more important to them, creditors, things like that. So they don't see it as a plus.
And
being
lawyers
transparent.
get in the middle of it.
Yeah, no, yeah. See.
Boards lawyers.
Board
I mean.
lawyers, yeah, and then they're consultants. You know, it was. We don't have the picture, but the day of the U.S. Supreme Court oral argument, you know, we had a pro bono representation. You know, we were all working on the payroll, working for free, and the board took their entire team of attorneys from Proskauer. You know,
And
30.
apart from Puerto Rico.
In part from like 30 something, 40 something people, they took a picture in front of the U.S. The stairs of the U.S. Supreme Court, and they were like, they're all being paid by our taxpayer money. You know, they've flown them out for the argument. You know, we probably pay for the flights tickets. So you know, you can see the comparison. We know we're fighting this good fight. You know, but it's David and Goliath kind of thing.
Yeah.
The next one.
Okay, so thank you. Thank you.
Thank you.
Centro de Periodismo will have a brunch on Sunday. So you have the information. I think it's on the table,
On the
flyers, so you can come by and we'll talk more in Spanish. Bye.
Yeah.
Thank you.